Alan Bobo. So
Yes, sir.
everybody's here for this case? Okay. All right, let's, you know the ground rules. You were here for the intro, 20 minutes. The appellant gets to go first. If you want reserve time for rebuttal, let me know.
Yes, sir,
Wait.
please.
Yeah, we get everybody here. Go ahead, please proceed.
All right, thank you, Your Honor. May it please the court. Your Honor, I'm Alan Bobo, and may I reserve 5 minutes for rebuttal, please?
Yes, sir.
This appeal presents de novo review of the interpretation of a deposit order that had been appealed to this court and affirmed, and the associated rent deposit statute. The bottom line here is, Your Honors, we had a tenant in a landlord-tenant case who was ordered to put money into the court registry by a certain date and in a certain amount. That tenant failed to do so, and in spite of that failure and the black letter law that surrounds that failure, the trial court refused to enter a judgment for possession against the tenant in the case. Now, the whole matter.
Mr. Bowe, let me interrupt you, because we have a conclusion by the trial court that the rents case order did not apply to this tenant. And so if that is the order that you're relying on, don't we have to first start with addressing that conclusion, whether it applies at all?
Let me go both directions, Your Honor. Let me first address the order that you're talking about, or I'll address the order that you're mentioning. But the order that was in default, and if you look at the basis for the complaint, the eviction action was filed against the tenant because the tenant failed to comply with the Hayes deposit order. We had a lot of these cases filed, Your Honor, scores and scores and scores of them. We were separated, and I don't know whether we had 6 judges or whether we had 10, but it was something like that. And we got a lot of different orders from the county courts in connection with these type of rulings when the cases first started, which resulted in all the cases getting pushed up and handled by one judge so that we didn't have the inconsistent rulings. But let me focus for a second on the ruling that you're talking about. You're talking about Judge Provost's ruling on the order determining rents. Your Honor, that was made by a county court judge, Provost, in August of 2016. If you look at the ruling itself, it just says that the deposit order that was entered by the chief judge of the circuit court and approved by this court was somehow not binding on these class representatives. At the time that order was made in 2016, several things had happened. The chief judge and the circuit court had entered the deposit order. It was intended to be binding on its face. The homeowners association had appealed that order to this court. This court had affirmed the entry of the deposit order. The other thing that had happened at that time is the court had entered, the 4th District Court of Appeals had entered its opinion in the Hollywood decision that is cited in the Judge Hayes deposit order. And let me tell you the materiality of that one, Your Honor. The Mobile Home Act was created in 1984. The rent deposit statute for the Mobile Home Act went into existence in 1984. In 1988, the Supreme Court of Florida created Rule 1.222 of the Florida Rules of Civil Procedure. We didn't know after that rule was created how the deposit statute would work in a class action setting. And we didn't know that until 2011. Judge Provost ignored that opinion where the 4th District clearly held that the deposit statute in the Mobile Home Act was applicable in a class action proceeding. And the court held that the tenants who were disputing rents were the real parties in interest in the litigation. Therefore, it was appropriate to require them to put money into the registry of the court in a class action proceeding. That was the only opinion that existed. This court had not ruled contrary to the 4th District. In fact, I counted, the Hollywood decision has been cited to this court at least 22 times in briefs. And it was argued to the court when this Hayes deposit order was entered.
So if I understand you correctly, you're saying that Judge Provost's order has basically been superseded over the course of the proceedings.
But it was honestly, Your Honor, I think it was in error when it was done. He failed to follow his circuit court, he failed to follow this court, and he failed to follow the only decision that was out there, which was the Hollywood decision. Did I answer?
Yes, thank you.
As I said, Your Honor, this started with a rent strike. We had 400 tenants who were out there basically refusing to pay rent. We had 400 of them out there in 400 different circumstances. Some were paying part, some were paying less. And the court was asked to enter a ruling to put this money into the registry of the court so that everybody would be paying the same thing and it would be safe. After a couple of evidentiary hearings, Judge Hayes entered the deposit order. I'll call that one the deposit order. Judge Hayes entered that deposit order. It was very tenant friendly. It allowed the tenant the option. So for this particular tenant, she could pay $600 to the park owner, or she could pay something less so long as she paid the balance into the court registry. It was her choice. That deposit order was appealed. All these arguments about due process, the Hollywood decision, everything were entertained in that appeal before this court, and this court affirmed the entry of the deposit order, at which point it became the law of the case. Now, the tenant here received a copy of the deposit order. Her testimony is very short. She admits that she received a copy of that deposit order. She admits she knew what to pay. And in fact, she did make one payment. She made one payment on the deposit order on time, in the right amount. And then she confirmed that thereafter, for at least a 24-month period, she failed to pay the park owner the $600 that was ordered by the judge, and she failed to put the balance into the court registry. That's admitted. All that is undisputed. She is in default of the Judge Hayes deposit order. That's undisputed facts. Now, the trial court made another error on this. We tried the case not only on possession, but we tried the case on damages as well. The trial court entered a final judgment for the park owner, but the damages were awarded only from the date of filing of the lawsuit. So remember our situation. This resident is told to put $600 into the court registry or pay it to the park owner. She doesn't do either for 24 months. She pays basically $100 less every month for a number of months without putting the balance into the court registry. When the court entered the final judgment for damages, the court forgave all that past problem and only gave us a judgment for damages from the date of the filing of the lawsuit forward, not any of the default in the Hayes deposit order that this tenant had committed. So she says, essentially, she's still there, and she was rewarded for not paying the money that was ordered by the Hayes deposit order. The tenant makes two arguments here. First of all, they argue that the deposit order doesn't apply to her because she was simply a putative class member. And secondly, she infers that perhaps the trial court found that the park owner was guilty of waiver or estoppel because during these 24 months, the park owner accepted less than the full $600 that was ordered by the trial court. That's basically the setup. It's important for me to point out here that this is not a one-off case. I think we have 38 more of these that are waiting to be tried. So it's an issue that goes beyond this particular case. I've talked to you a little bit about the deposit order. The deposit order was not created out of whole cloth, Your Honor. If you look at the deposit order entered by Judge Hayes and confirmed by this court, it comes right out of the rent deposit statute, and it even cites to the Hollywood decision saying that I'm obligated to tell the residents they have to put the disputed money into the court registry. So Hollywood was binding upon Judge Hayes. He recognized it. And this court has never receded from Hollywood. And I'd suggest to you that you don't want to. In these class action cases, how are we going to handle rent deposit matters if they apply to 400 people? We can't have 400 rent deposit hearings. I think the 4th District got it right when they said, let's have one rent deposit hearing and we can have it for the entire class of the real parties in interest who are contesting their rent.
Mr. Bobo, do you need law of the case? I mean, is there another rationale by which you can allege or you could argue that you made your case, that the damages for the period that began, the time that ended, for the period prior to your filing of the action were proven because you proved that you had put them on notice that the rent was at Y amount, but they only paid X amount?
100%, Your Honor, I do not need the law of the case. I mean, the law in Florida is that these rent deposit statutes create, you might have seen the bar articles, a pay-to-play eviction statute. So if you want to submit defenses to an action for possession or an action for rent, you have the obligation, even without a court order, to put the disputed money into the registry of the court.
Let me reframe it. Let me reframe it from a situation in which we're talking about a tenant waiving the right to assert defenses other than payment, and talk about because in that what it sounds like to me is the way it's being perceived is, well, their defense of estoppel waiver was waived because that is debatably, but it is a defense other than payment. And the reason why that was waived is because they didn't take, shelter in the, by paying the balance into the registry. But alternatively, is it possible that we don't need to worry about any of that if you made your case that they just didn't pay the rent they were supposed to? And was that case made? And if so, why didn't the court credit you in the judgment for the rent that was not paid prior to the filing of the lawsuit?
I have no explanation for the last part of your question, Your Honor.
But walk us through how you made your case that
the
rent was X and they only paid Y.
There were no gaps in the proof, Your Honor. We put on management employees who testified as just to what had been received by this particular tenant. It was less than the amount of that the court had ordered in the deposit order. In fact, in the demand that we gave this tenant, we gave the tenant the demand for rent. We gave the tenant the accounting for the payments that the tenant had made, and we gave the tenant a copy of the deposit order that she had already received. So there were no gaps in the proof. That was the proof of what the tenant had paid. And then all we had to have to prove that no money was paid into the court registry was the clerk's information on the payments that were made into the registry. So we know that she didn't make the $600 payment that was required. She admits in her testimony that she didn't make that payment. And now we know that none of that disputed money, the corresponding balance, was placed into the court registry. So yes, sir, I think that gets us to where we want to go. Why the court made the ruling he made on the damages, I don't know. This court has followed a long and unbroken line of cases that in a landlord-tenant dispute, if you receive a court order, you've even said if you don't receive a court order, you dispute the rent. But if you receive a court order to put the money into the registry, you have to do that in order to raise any defenses other than payment. I don't understand the ruling because I think we got there from about 3 different directions. Why he made the ruling on the amount of damages, I don't know. We did try to follow the appropriate procedure, Your Honor. We did go back to the court with a motion for rehearing and said, can you please explain how this was done, how this was figured? And we were denied on that motion. So we did try to go back and get an understanding, but in this case, the tenant really makes the 2 arguments. They say, number one, we weren't bound by the deposit order, but they have no authority that they can rest their hat on for the deposit order because the Hollywood decision is there. The Hollywood decision is binding upon the trial court. It was binding upon everybody that says the tenant is the real party at interest and a rent deposit statute applies in a class proceeding.
Let me ask you this. If is it possible that to perceive of this case as one in which the defense that was asserted was payment? In other words, well, we didn't have to pay $600, so because we had this oral lease or whatever, and so in other words, we waived waiver and estoppel, but we didn't waive our right to assert the defense of payment, and you got to prove that we owed that $600 sum during the time that we didn't pay it. Okay,
there was some argument in the briefs by the tenant that we didn't know what to pay. The tenant actually inherited the home. This is the second home. The tenant inherited the home in 1995. In a mobile home park, I want to be clear about this. In a mobile home park, when you move in, you either sign a lease or you enter into an oral lease agreement. But the concept is that you're likely going to be there for years. The statute has a very extensive process. So when you increase the rent over time, you can only do it once a year. When you increase the rent, you've got to give a 90-day notice. There are opportunities for the residents committee to meet with the park owners. It can go to mediation, and it can even go to arbitration before it goes to the court. So the fact that they said we didn't know what to pay is wrong, because first of all, there's a process for rent increases in the statute, which were followed, which resulted in the rent strike in the first place. Secondly, in her trial testimony, the tenant admits blatantly at R-492 that she was ordered to pay $600. So this is not a payment case, Your Honor. Then right after that, the next page, she admitted that she didn't pay that amount of money. So we are back to, is the deposit order binding upon the tenant?
Mr. Bobo, I was trying to remind you, you're below your 5 minutes. You can either keep going or save 5 for your rebuttal.
I'd like to save the 5, Your Honor.
All right, you got it. Thank you. Mr. Christopher, you're up.
Thank you, Your Honor. May it please the court. I'm Donald Christopher. I represent the defendants below, Ms. Mustin and her husband, William Bailey, as well. I won't refer to Mr. Bailey because I'll just call it the Mustin case. The first leap of faith that the landlord has made here is that the June 21, 2013 deposit order set the rent going forward. I don't see anywhere reading that order that it set the rent going forward. All it said was before September 9th, you need to pay into the court registry the difference between whatever you paid to the landlord back to May of 2017 and $600 a month.
Yeah, but let me ask you this. Do we look to an order to pay rent into the registry as a definitive adjudication of what the rent should be? Isn't the purpose of that order to put the disputed amount in the registry? So
exactly,
in other words,
Your Honor, but the way the order reads, the disputed amount was the amount that was the difference between what had been paid since May of 2007 and September 9th of 2013. And it didn't say anything. If you look, for instance, at the county court's order, Judge Provost order in this case, he ordered that after hearing the rent's determination, he ordered that the tenants had to pay the sum of $11,169.73 less what they already had on deposit in the court registry. And then thenceforth, he's got a second paragraph and he says they have to pay that and they have to pay $600 a month, which they did. The Judge Hayes deposit order doesn't talk about any future payments. It talks about just the difference between whatever you paid from May of 2007 up through September of 2013. In fact, Ms. Mustin paid that amount. She made a deposit, as the landlord has conceded, of $8,782.95 on September 9th.
So 13 to 15, she didn't pay in the registry, right? Is that right?
Exactly. She had an oral lease. She didn't know that she was supposed to be paying $600, and I submit that nobody could know. Mr. Bobo argues that it's apparent. It may have been apparent to the landlord. That may have been in the landlord's mind. But let's look at what happened here. What happened?
Let me ask you this. Sorry to interrupt you. Sorry to interrupt you. Real quick. If the landlord won, essentially, by establishing that the rent at the higher amount was appropriate and was the rent, then how can you say that during the time period she didn't pay into the registry, the rent was lower?
Because, Your Honor, she had an oral lease. She made these payments. If you look,
what was the theory on which the trial court decided that, yes, you starting on 2015, you were supposed to be paying $600 something a month? What was the theory? I mean, what was the rationale?
The rationale was, first, the county court's order that the deposit order did not apply to this tenant.
No. What was the rationale for the landlord to win on the issue that the tenant owed X amount of rent?
What was the
$600.
theory for the landlord to win, Your Honor?
Yeah, landlord won, right?
Right.
So
The
what was the
landlord
rationale? Establishing the rent was what the tenant had failed to pay after 2015.
Right. Only the tenant had paid all that. It was
Into the registry.
Into the registry, exactly.
It was in dispute, and your client lost the dispute about what the rent was supposed to be, right?
No, Your Honor, we didn't. We won the dispute. The court said that the rent that you've paid from September of 2013 up through the filing of the suit in October of 2015 was all that you had to pay, because the landlord accepted all those payments. The landlord never gave my client any notice that any of those payments were deficient. My client had no idea they were deficient. My client had an oral lease, and under an oral lease, the party's course of conduct is the only evidence that you can have as to the amount of rent under the lease.
All right, I have two questions for you. One question I'll start with, because I already asked it. So would you agree or disagree that starting on 2015, the date, whatever the appropriate date was in 2015, the court found that the rent was appropriately higher than your client thought it ought to be?
Well, there
Right?
wasn't a specific stipulation, but I think both
I didn't
parties.
say stipulation.
agreed.
I said you lost on that, right?
Right, we lost on that. We never made a contention that the rent was any less, because again, we didn't know that the rent had been raised to $600 a month. You can't. They keep relying on this Judge Hayes order, which Ms. Mustin was not a party in that case, has never been a party in that case. There's never been a class certified, notwithstanding an order finally in January of 2019 to give notice to the class members. And this is an involuntary class action. So my client had no idea that they were supposed to be paying $600 a month.
Well, this
The
was an
landlord-
action by the HOA, right?
Pardon me?
It was an action by the HOA. And by statute, the HOA represents every tenant. It doesn't say every one with a contract or a written contract. It says every tenant. So why would Ms. Mustin be excluded from being represented by the HOA?
Because my clients weren't represented by the HOA.
Okay,
Mr.
well,
Bobo
but why?
I'll explain, Your Honor. Mr. Bobo keeps talking about the Hollywood case. There's a significant distinction between the Hollywood case and what happened in Naples Estates. In Hollywood, the homeowners association was the plaintiff and sued, claiming that the rent increase was improper. And they sued as class representatives on behalf of all the homeowners. And under the statutes, an HOA can do that if they get the prior written consent of a majority of the homeowners, because HOAs in mobile home parks are all voluntary. They're not like an HOA in, say, a condominium or in a particular development where when you buy the property, you're automatically a member of the HOA and subject to its requirements. In this case, the homeowners association did not file the 2007 case. They were an involuntary defendant. The landlord tried to make them an involuntary representative of all the homeowners. The court never ruled on that. A class has never been certified yet. And I submit that there's a substantial difference between when a landlord sues an association, which is a voluntary association, hasn't secured the consent of its members, and no notice was given to Ms. Mustin. She didn't know that the court was having this hearing on June 21, 2013, presumably she was entitled to notice of that hearing if she was somehow a party to the case. She didn't have notice of that hearing. She didn't have an attorney in the case. She had nobody arguing for her. And so therefore, I don't see how that order can be binding just because the HOA did it. Because again, there's no showing on the record in this case that Ms. Mustin was either a member of the HOA or should have been bound by that. The one thing that is evident in the case is that she did pay when she got a copy of that June 21, 2013 order. She did pay the $87.82.95 into the court registry. Now, I guess you could argue that that's somehow a consent or acknowledgement, but again, I wasn't representing her back then, but if I was her attorney, I'm not sure what I would have told her.
Well, can I ask you about that? Can I ask you about that? So, and this is something that is comes up in my mind, and I'm not sure it was covered in the briefs, but it's a theme that I've established for my questioning today, and that is that is the question of whether reliance on that order is necessary. I mean, there's different ways to rely on it. One is to say, well, she was bound by it. Another way is to say, well, that's proof that she knew that the landlord was demanding a higher rent than she was paying. And under the statute here, it doesn't say anything about really, I mean, it just says, in any action based on non-payment, the mobile homeowner may defend on material non-compliance. But you can only defend on material non-compliance if you and it's not a material non-compliance cases, but the cases have said that if you didn't pay into the registry the difference, the disputed amount, then you don't get to defend on anything except payment. And she's obviously not, she's admitting that she didn't pay what they wanted her to pay, right? So that's what a defense on payment is. I paid what you said I ought to pay, not I paid what I think I ought to pay.
No.
So why does the landlord have to rely on law of the case or on this order being binding on her instead of just making the case that you knew we were charging higher rent and you didn't pay it?
What's the evidence that she knew?
Well, I'm playing the devil's advocate.
Oral lease. Nothing in that order says.
But you just said that you just acknowledged an argument that, and I'm just making it as a devil's advocate here for both sides, is that she made a deposit saying, oh, there was a difference in what I paid and what they think I owed. So she knew that they were charging more.
Right. But go back and read the June 21, 2013 order. That deposit was in compliance with the order that said you must deposit the difference between what you've paid every month back to May of 2007 and $600 per month. She did that. The order does not go on to say anywhere that henceforth in future months your rent is $600. Now, so she went back to paying what was her normal rent. She paid it. The landlord accepted the checks. The testimony is that the landlord never gave her any notice. Hey, your rent's $600 a month now. You need to pay the difference either to us or into the registry of the court. That never happened. She didn't know that. And that, under the case law, constitutes a waiver of their claim. And that was the basis for the trial court's ruling that, hey, you accepted all these payments from September of 2013 up through the filing of the suit in October 2015, and you didn't say anything.
Well, isn't that because pursuant to the rents order, the mobile home park assumed that the payments were being made pursuant to the order into the registry, and that's why it was accepting the lesser amount directly? So it wasn't saying, we know you're paying less and we're fine with it. They were saying, well, there's this court order, so we're assuming what you're paying, you're paying what you're supposed to into the registry. So that wouldn't be a waiver, would it?
Of course it would, Your Honor. Where does that order say that you must make payments into the registry after September 9th of 2013? It's silent. It doesn't say that. At best, it's ambiguous. In that circumstance, when my client made a lesser payment in October of 2015, the landlord should have said, wait a minute, have you paid your rent $600 a month now? Either pay that to us or pay it into the court registry. They did not do that. And
wait a minute.
now, after the fact, years later, they're saying that my client should have somehow read that order, read between the lines, and known that her rent was $600.
Let me ask you this: were there other tenants that were made aware that the park was demanding a higher rent?
Not that
Was
I'm
the only
aware.
way to be notified of higher rent the order?
The park filed suit against, I believe, 15 tenants in December of 2013. Initially, the county court dismissed those suits on the basis that the deposit order was not binding on those tenants and it violated their rights of due process to hold them to that order. And then subsequently, that was reversed when this court per curam affirmed in the association thing.
Let me ask you this: are you saying it was because it was never adjudicated essentially how the tenants in this case were notified of their obligation to pay a higher rent during the time period that the damages were assessed, meaning 2015 onward, and that's just because they just said, yeah, sure, whatever, we paid it. That there's no evidence that they knew before that. I'm not sure I even am able to discern that question, but hopefully you got something out of it. In other words, somehow it was either stipulated or the court accepted or found that, yeah, you know what, as of some point, the rent's $600. And this all has to do with what?
The order does not say that, though.
Which order?
The June 21, 2013
No.
order.
The order at some point, sympathize with, you don't have to sympathize with my colleagues. They're smarter than me, but sympathize with me. I'm sitting here looking at a case in which the upshot is at some point at 2015, everybody's like, yeah, the rent's $600. And this is all about the fact that at some magical time before that, the rent wasn't $600; it was something less. How do I square that? The point is that the rent was $600 between 2013 and 2015, the filing of the suit, just as it was between 2015 and the resolution of the suit. Right?
No. A tenant has to be put on notice. The tenant, by the filing of the lawsuit,
how was the tenant put on notice? The lawsuit?
The lawsuit and the demand for payment. And then if you look at the motion to dismiss and to determine rents that the tenant filed timely upon receipt of the lawsuit in October of 2015, the tenant said, hey, wait a minute, I made this big deposit, $8,000 some odd dollars back in September of 2013, and you're seeking rents back to 2011. So presumably that deposit covers part of the time from half the time from 2011 to 2013, but not the other half from 2013 to 2015. That was the premise of the motion to determine rents. In the meantime, the client said, okay, you're demanding $600. They paid $600 every month in the eviction action into the registry of the court. When the county court finally got around to hearing the matter, the county judge said, yes, I determined that June 21 order is not binding on you, but I'm going to have you pay the $11,000 less the amount you've already got on deposit in the registry of the court, and that will cover $600 a month up through the time of the hearing. And the judge put a specific paragraph in there where he said, from now on, you got to pay $600 a month. My client complied with that fully. And the judge also, if you look at the county court judge's order, he specifically reserved on the question of whether there was an estoppel here by acceptance of a lower amount of rent. I argued that to the trial court. We had evidence on it. The evidence was that the landlord gave no notice, no objection, no return of checks to my client. My client said she didn't know that she was supposed to pay a higher amount. She thought she was supposed what she was paying. The landlord accepted her check. And
The county court
on
judge-
an oral lease, that's
What did the
all that
judge
you
do?
can expect the tenant to do. And that's why the trial court said, okay, you can get $600 a month going forward from the filing of the lawsuit, but you can't collect these amounts you claim are due before then during the 4-year statute of limitation.
So you're saying that's the equivalent of finding estoppel or acceptance for the previous deficiency?
Yes, Your Honor.
All right, thank you.
That's what I expressly argued. If you look at the amounts in the written closing argument that.
I hate to inform you,
So
but
let me ask you this. So you're,
wait a second. You just ran out of time. Unless
Okay,
that's
never mind.
vital, Judge, maybe we can move on to the rebuttal.
No, thank you.
All right, thank you. All right, Mr. Bobo, you've got 5 minutes left.
Let me see if I can go backward, Your Honor. First of all, how much do we pay? She admitted in her testimony at R-429, I think 3 different times she admitted in her testimony that she knew she was supposed to pay $600. If you look at the written closing that was submitted by counsel on page 4 of the written closing, again, she admits that she knew the money was $10,000 or $6,600.
We'll start with analyzing his last statement that the county judge, in essence, found waiver estoppel as the previous deficiencies not paid into the registry. Is that true or false?
Say that one more time, please, Your Honor. I'm sorry. And I don't mean to
Your
waste my time.
opponent just ended with the following information or assertion that the county judge effectively found waiver or estoppel for the previous deficiencies because of statute of limitations or something to that effect. Do you understand the question now?
I do, Your Honor. He
All
could
right.
not on that motion have found a waiver and estoppel. In fact, if you read the rest of his ruling, he left that for a future consideration of whether there's a waiver and estoppel.
How do you know he did that?
Huh.
How do you know he did that?
I'm
How
sorry,
do you know the judge did that?
it says it in the order.
So you read it to me, please.
I have it here somewhere, Your Honor.
All right, if you can't find it, move on.
I do have it. Okay. All right, let me move on, my time's short. Your Honor, you asked, were the other residents notified of the $600 required payment? If you look at the rent deposit statute, if the court finds that a certain amount of rent has to be placed into the court registry, there has to be notification to the homeowner of that responsibility. The court required us to give notice to all the homeowners in Naples Estate of the rent deposit order, which we did. An affidavit of compliance was filed in this case, and the tenant admitted she got that order. There was some argument made by counsel. Let me go back to you, Judge Valenti. There was an argument made by counsel on this waiver and estoppel deal. Basically, the argument counsel makes is we're putative class members. The deposit order doesn't apply to us. The question that I think is appropriate is, does that deposit order that was entered by Judge Hayes, does that apply to the mobile home park owner? We asked for it. We litigated for it. We put on evidence for it. When it was appealed to this court, we stood behind it and gained the affirmance of this court. It was binding upon us. This was not a situation where we could sit back after having a judge say, you got to put $600 in the registry. This was not a circumstance where we could look at a check for $500, let's say, and then say, oh, that's not the correct amount of money. Therefore, I'm obligated to send it back. Otherwise, I'll have a waiver or estoppel argument. As the court points out, we were ordered by Judge Hayes to accept less if they submitted less. And all we had to do was try to make sure that they put the rest of the money into the court registry. But as you know, there's always a delay on that. We will never know at the time that we take that check and we deposit it, whether that tenant has complied with the court order we have to assume that they would. So this is not a normal landlord-tenant case where we intentionally accept less than the amount ordered because that money had a corresponding obligation to be deposited into the registry of the court somewhere else. Court asked, doesn't the homeowners association represent everybody in one of these class action cases? The statute, Your Honor, is 723.075. And it says, upon incorporation and service of the notice, the association shall become the representative of the mobile homeowners in all matters relating to this chapter, regardless of whether the homeowner is a member of the association. For this homeowner to not pay the full amount of rent into the court registry, the full amount of rent to the park owner, for that not to happen, a prerequisite's required, as in all rent deposit statutes. You have to give a 7-day notice to the landlord that you're not going to pay and why. A 7-day notice was given by counsel for the homeowners association on behalf of all of the residents, including the tenant here, that these residents would not be paying all the money to the park owner.
Mr. Bobo, just for your information, you've got half a minute to wrap up.
Thank you, Your Honor. And the only thing I would add is I believe the tenant in this case intervened. The court has made a ruling. The deposit order judge, Judge Hayes, has made a ruling that the deposit order he entered was continuing in nature, and it contemplated the residents continuing to pay $600 per month, either to the park owner or the balance into the court registry until the case is decided.
And that's the last word. Thank you very much, gentlemen. Well argued, good passion. Have a nice day. Safe travels.